Welcome for day 2. Welcome to day 3. Today's resource persons is Madam Priyanka Chakraborty, who is the advocate and accredited mediator and executive secretary, Bangladesh International Mediation Society, BIMS. Today's topics will be the process of mediation, 2 stages of mediation, role of mediators. And today's summarize this program, Madam Asha Mahant, who is the accredited mediator and solicitor in England, and also Director General People's Mediation Center of BIMS in Bangladesh. All are welcome to today's program. Now, we are requesting Madam Priyanka Chakraborty to present your topics.
Thank you so much, sir. Good morning, everybody, and apologies from my end. Actually, I misjudged the time. I thought it's 9:30 a.m. India time, whereas it was Bangladesh time. So sorry for the delay, everyone. I am more than glad and honored to have this platform to be able to, talk about mediation and discuss it throughout today. So starting off, the topics of me today are that I'm going to cover is the process of mediation. What are the steps that we follow when we are practicing mediation? And pertinently, what is the role of a mediator? Now, these are actually very practical topics, since we are doing it online, I have tried to come up with a couple of exercises that we would do, and it would be great if we can participate and practice that. What I would suggest is when we take the first break, maybe all of you can form groups of 3. Maybe the admin can try and arrange that. And then you can have a practice of, practicing mediation within the group of 3. And then we will all come back together and we'll discuss what happened in there. Okay, so we are going to do some of those practices. Well, widely, if I have to talk about it, since today is the 3rd day, I know, we are all aware of what is mediation primarily, and an idea of what a mediator does and what is happening throughout the process. So without any further delay, I will just start off with my presentation for today. Please let me know if you can see my screen.
Yes.
Yes, we can see. Okay, great. Thank you so much. Okay, so let's talk about what is the process of mediation. So when we say the process of mediation, what we try and understand is basically an extension of what is mediation. So we can say it's basically an informal and flexible dispute resolution process, right? And what the mediator does is basically is the person in between who guides the parties towards their own resolution. Now, how do you prepare for a mediation? So what I'm going to talk about right now is from a generic point of view. Okay, so let's say if you have clients or if you have parties, or you are somebody who wants to take up mediation for that very reason, what all needs to be done to prepare for a mediation, okay? So the first and the foremost important thing is to decide when to mediate, okay? When to mediate means what is going to be the triggering factor. We all know that, let's say, for example, if there's a contract, whenever there's a breach in contract, that becomes the trigger point. That, okay, if there's a breach in contract, we go to the court, okay? Or if there's an arbitration clause in the agreement, then we know that if there is a breach in either of the clauses on the contract, then the arbitration clause will come into place and and we can go for arbitration. Likewise, there has to be a triggering factor and you have to decide when you want to go for mediation. Now, since mediation is not as widely practiced in countries like India and Bangladesh, like in our countries, what happens a lot of times, we end up mediating once we go to the court. So when we go to the court says that, no, you should take this for mediation first. So it's more of a referral sort of a situation for us, okay? We are referred by the court. Or maybe we are in litigation for, let's say, like 15, 20 years and, the case is not getting resolved. And then somebody suggests, why don't you try mediation? So you then start mediation. And I have also come across a lot of people who are now, at least for family cases and property matters, they try and get in touch with the mediator and say that, okay, let's try and mediate first before we even step into the court. So when do you want to mediate is something which is very important to decide and understand. Okay. Secondly, you have to learn about the mediator. The person you are approaching to mediate for you is very important. Okay. You need to see whether the person is competent enough, whether the person is trained. Okay. And the person is qualified, and the person is genuinely trying to resolve the issue. Okay. And is not just trying to score numbers like, oh, I resolved 10 out of 11 cases that came my way. That shouldn't be the attitude of a mediator. A mediator's mere job should be to help the parties come down to a resolution. Another important preparation before mediation is to analyze your case. Okay, you need to understand your case. You need to understand where you stand, where the other party stands, what are your demands, probably what is going to be the demand of the other party, and somewhere in between where you think, okay, this is how much I can let go. Okay. So that sort of an understanding and analysis of the entire scenario should be there. You should be very well prepared, okay? And it shouldn't be, mostly what happens when you are in a dispute, people tend to think only about themselves, okay? That I was done such wrong, আমার সাথে এত খারাপ হয়েছে, আমার জন্য আমাকে এরকম করেছে, আমার এত খারাপ লেগেছে, আমার এই ক্ষতি হয়ে গেছে, আমার এটা হয়েছে, আমার. So it is all about us at that point. Instead of that, you have to also understand what the other party is thinking. Okay, you have to try and analyze the case in its entirety, create an analysis of it. So how do you create an analysis? As I said, there are two ways to do it. One is BATNA and VATNA, which is the best alternative to negotiated agreement, and one is the worst alternative. If you haven't already discussed, I have some parts which we will discuss through, so not to worry. In raw sense, it basically means that if I do not settle through this mediation, what is the best alternative that I have? And what is the worst alternative? So for example, if I do not settle, the best alternative is I go to the court and I win the case. And I, let's say, get a compensation of 2 lakh rupees for the damage to my car. And what is the worst alternative that will happen? I go to the court, I lose the case, and I have to pay a compensation of say 50,000 for the harassment and the court case charges. And apart from that, I also have to pay my lawyer and all the harassment, and my car is already damaged. So that's the worst case scenario that's going to happen. So you have to have that understanding of what is the best possible alternative and what is the worst if I do not settle here. Having that sort of an understanding is very important. Okay. These might seem theoretical to you right now, but these are very practical things. And when we are going to practice mediation today in the later half of the day, you have to sort of understand and follow these sort of steps. Okay, so please, like, if you want to note it down, you could, or however you want to do. But these are very important things that needs to be taken into account in practice. Then apart from that, you have to prepare an effective and persuasive mediation statement. Okay, so what is a mediation statement? Basically, it's the opening statement in mediation. So when you, we'll talk further in the presentations below, but when you start a mediation, you start with an opening statement. Opening statement is like your story. Okay, what are your facts, what you believe happened, what do you want? It's a complete summary of your perspective to the dispute. Okay, so you have to prepare that very well. Okay, because that is how you start the entire thing. That is where you set the tone. Now you might think that it is a good idea to set the tone very high, like, okay, this is what happened to me, I am right, and I will not accept anything. Let's say there is a damage of car and that's the dispute. So you say that I will not accept anything below 3 lakhs and that is it. So you try to show yourself as very strong, but you're forgetting that if you are showing yourself that hard, the other party might not budge, and they might say, okay, they are very egoistic and they already know what they want. So I'm not willing to give that. So let's end this. Let's not settle. Okay. So setting the right tone is very, very important. So you have to prepare your mediation statement very, very well. Okay. consider a conference call with a mediator before mediation. It's a very interesting and a very important thing. We don't yet have it, but a lot of private mediation practitioners are putting this into account. I had witnessed it outside when I was doing my master's outside of India. So they have this concept called pre-mediation counseling, where the mediator meets up with the clients individually and they discuss about the case, and the client also gets to know from the mediator as to, you know, how they want to mediate and what they want to mediate about, and how this should come across and how it should be, and what is to expect, and what the person should be behaving like. You know, you shouldn't be too soft. Like, you shouldn't be like, okay, you take this, okay, you take this, you shouldn't be too soft. Neither should you be too hard, like, no, I'm not going to give you anything. So there has to be this middle surface. So it is basically the mediator who sets the tone if you have a pre-mediation counseling, and it helps further in the process of mediation. Okay, then you will decide who will attend and who will speak at the mediation. Now, this is also very, very important, okay, to decide who is going to come into the mediation room with you. Because if you want to, let's say, bring your lawyer, the other party has to approve that, okay, it's okay if they bring the lawyer. The other party might also want to bring their lawyer. Now, this is a perennial problem when it comes to family disputes. I have had a recent case, a divorce case, where the husband wants to bring his sister as well, because, I don't know, there's no reason. He just says that he's more comfortable when she's around. So that's just the thing, okay? But that's unfair, because then I explained it to the husband that if you are going to bring your sister, then your wife, A, might not approve. B, even if she approves, maybe she will not be comfortable enough, okay? So in such scenarios, it gets very, how do I say, it gets very disruptive and it gets very uncomfortable. And also to understand, it's a confidential process. The main idea is that parties should be in a comfortable zone to participate. So if you bring unnecessary additional people to talk, it just sets the course of dispute in a wrong direction, okay? So it is very important to decide who will attend and also who will speak. You might feel that having somebody right next to you will make you feel comfortable, but the person does not need to speak. That's a different thing, okay? It happens a lot of times when you have like a very unbalanced sort of a dynamics between two people at two ends of the table. And that happens primarily, for example, you know, if there's a lady, and I'll tell you this example. So there's this employment dispute that happened, and it was basically on one end of the table, there was a black lady of the age 30 to 35. And on the other end was her boss, and he was a old white English man, I think in the range of 60 to 65 years of age. So they couldn't have a balanced conversation. And then the lady said that, you know, can I have my friend along with me so that I feel more comfortable? Because she was feeling intimidated by the other man, okay? So sometimes in such cases, you can have somebody like that just for support, but that doesn't mean the other person is going to participate in it, okay? So that is something which is important. Now, let's talk about the process of mediation. Now, these are not particularly the steps, but understanding how the mediation process basically flows. What is the flow of the mediation, okay? So one is introduction. So the moment you start with, you know, mediation, you have to start with introduction. There has to be an introduction and understanding of who the parties is, who is the one person mediating, and who is going to be in and around. So all of that, okay? So that is the start. So process of mediation has to start with an introduction and understanding of who the parties are. Then it slips into understanding the problem. So then you understand what the problem is, okay? I think I haven't shared the screen properly. So it's not in the slideshow manner. Yeah, this looks better. So understanding the problem comes next. You have to understand what the issue is, and you know, what's the background, the fact. And then you have to understand, you have to sort of like get into the problem and try and understand what are the interests and needs. I will discuss more into the details of position and interest and understanding of such with the parties. But for now, we can say that we have to have a deeper understanding of the interest. Basically, it means that what is it that the parties actually want? Okay. So I'm handling a divorce case currently. And the issue is both of them are not compatible, the husband and the wife. And the husband has extramarital affair, the wife has extramarital affair. And in the middle of all of these, they have a daughter who is 2 years old. Okay. And they had a daughter thinking, the husband says that I had a daughter thinking that my wife will get better and she'll concentrate more on the marriage. And the wife said, I just had the daughter because my husband insisted me on having a daughter, and I don't know, I just gave up and I had the daughter. So this is a very, it's a very sad and a very tricky sort of a situation here. And that's it. So the husband says that I am not going to pay anything other than my daughter's education. And the wife says, I'm not going to take any money, but I want a concrete understanding that you're going to pay for your daughter. So, I need those. And she has created this estimate in a table, which is like 80 lakhs. So her claim is, I know my husband, he's not going to pay eventually. He is just going to, make me run after him. He's going to unnecessarily drag me to the court and make my life really miserable. So I just want it in one-time settlement, and I want 80 lakhs. I think 80 lakhs is sufficient to at least raise my daughter till her graduation days. Okay, now this is her estimate, 80 lakh rupees. So this is where they both stand. Okay, now this is their position. Now I want to understand what is their issue. So the husband's issue is he has paid a lot of expenses for his wife and his wife's family and everybody else, and he's tired and he doesn't want to pay anymore. But he loves his daughter and he wants to take care of his daughter. Okay. Now, since she is 2 years old, he knows he is not going to get custody. So probably this is why, just to be able to see his daughter, he's doing all these tricks and, saying, I'm not going to pay you unless you get her here and something like this. So this is his way of telling that I want to, excuse me, I want to, spend some time with my daughter. And the wife on the other end, maybe she feels that she has never been given importance and she has been dragged around a lot and she's always, been tortured and, not being heard enough. So she feels this is her way of taking revenge and, just not letting her daughter go to her father and, just saying that for once, you give me importance. So I think her way can give me importance. That I can. Now, the next point comes down to defining the problem. Now, once we understand what the parties need, we need to define what the issue is. Excuse me, somebody's voice note is open. Can you please unmute yourself? Thank you. So then comes down to defining the problem. Now, what is the problem at hand and exactly how we are going to deal with it? So basically laying down and breaking the issues is very important as well. Otherwise, it's going to be a very clumsy scenario. Okay. Creating options. This is very, very, very important. And I'll tell you the story that I had seen. So there's this brother and sister, bhai bon ekjon chilen ebong tar মা মারা যায়, বাবা অনেক আগেই মারা যায়, মা মারা যায় ধরুন এটা আমি 3-4 বছর আগেকার কথা বলছি। তো তার মা মারা যায়, তখন ভাই বিদেশে থাকতো, ভাই বিদেশ থেকে আসে, এসে মার বাড়ি ছিল রাঁচিতে এবং মেয়ে থাকতেন বিয়ে করে বম্বেতে আর ছেলে থাকতেন ইউএসএ তে। তো ছেলে এসে মার বাড়ি, মা মারা যাওয়ার পর ছেলে এসে বলে যে আমি বাড়ি বিক্রি করতে চাই, অথচ বোনের দাবি যে না বাড়ি কেন বিক্রি করব, অসুবিধা কি আছে, আমাদের তো আর টাকার দরকার নেই, আর এটা আমাদের এত বছরের বাড়ি, একটা মা মারা গেছে তার সঙ্গে সঙ্গে বাড়ি বিক্রি করার কি আছে। So then they started having a dispute because the brother wanted to sell it. Then the brother said ঠিক আছে তাহলে পার্টিশন করে নাও, আমার ভাগে, আমার যেটা আমার ভাগে পড়ছে সেটা আমি বিক্রি করে দেবো, তোমারটা দিয়ে তুমি যা করবে করবে। But the daughter wasn't willing because the daughter was like এরকম কি করে হয়, আধা বাড়ি আবার বিক্রি করা যায় এরকম করে। তো it was a dispute, okay, and they were fighting this case for like 2 to 3 years, 2-3 বছর ধরে কোর্টে ঘোরাফেরা করার পর they had finally come down to mediation. So when they started talking in mediation, and in mediation actually onek lomba chole chilo, it went on for 15 days straight. And since bhai America থেকে এসেছিল, তো এরকম চান্স ছিল না যে ধরুন এক সপ্তাহে দুবার দেখা হচ্ছে, আবার পরের সপ্তাহে দুবার দেখা হচ্ছে, এরকম কোনো প্রশ্ন ছিল না। মানে যেটা হতো একদম এক নাগারে হতো, কারণ ভাইকে আবার ফেরত যাওয়ার ছিল। তো তখন কি হলো যে 15 দিন পুরো একদম মানে continuously for 15 days it went, and it was a very rigorous mediation. But it wasn't that complex a problem. But what happened at the end was when they started talking, they realized, so the sister wouldn't let. So then after a point, the sister said, why do you want to, sell it? It has all the memories of our childhood, how we used to play, how we used to fight, where we used to sit and study, and everything there. So why do you want to sell it off? Why do you do that? So then the brother confessed, basically, যে ওর আমেরিকাতে যে ও চাকরি করতো, সেই চাকরিটা থেকে ওকে বাতিল করা হয়েছে, এবং তার কাছে শুধু 3 মাস সময় ছিল হাতে যে সে ফেরত ইন্ডিয়াতে আসুক, এবং ইন্ডিয়াতে এসে সে আরেকটা চাকরি পেয়েছিল দিল্লিতে, এবং দিল্লিতে বাড়ি কিনে বা বাড়ি ভাড়া নিয়ে পুরো ফ্যামিলিকে আনার মতন তার আর্থিক ক্ষমতা তখন ছিল না। So the only way to deal with it was if he would sell this house, he would get the money and he would be able to bring his family. এটা একমাত্র, এটা ছিল মেজর রিজন। এটা যখন তার বোন জানতে পারে, তখন তার বোন বলে এক্সকিউজ মি, তখন তার বোন বলে যে তো ইউ ওয়ান্ট টু সেটেল ইন দিল্লি, দ্যাটস ফাইন। তখন বোন বলে ওঠে যে আমার একটা ফ্ল্যাট আছে দিল্লিতে, যেটা আমার নেওয়া, এবং ওটা খালি পড়ে আছে, and we are not doing anything with the flat. So why, so if you want to stay in Delhi, why don't you stay in my flat? So he said, but then the rent and everything. So she said, okay, I will, I'm not saying you stay here on charity or anything. You pay a minimum rent, যেরকম হয় 25-30 হাজার টাকা আপনি পে করবেন, তুমি পে করবে এবং তুমি থাকবে ওখানে, অসুবিধা কি আছে? এই বাড়ি বিক্রি করতে হবে না, আমাদের কাছে তো আছে অপশন। And after 15 days of, that crazy mediation that took place, there was the solution. They didn't have to sell the house. The brother got a place to live, and they had a good relation henceforth. So it all went well. It was such a miraculous thing, and that's what happened. Okay, so creating option is one. When you start to speak, when you tell what your real issue is, and you start sharing and you talk about it, you actually end up creating options which are viable. Okay, so this is what happened in such case. So it is very important for the mediator, for the lawyers who are mediating, and also for the mediating parties to speak more. Yes, of course, you shouldn't share out of the blue. If you see that the other party is not sharing, and you keep on sharing and sharing, expecting that আমি এতটা বললে হয়তো কিছু বলবে, that's not the right approach. But you have to sense the room, and you have to start, speaking up somewhere. So that's about creating options. And then once you create an option, you also have to evaluate the option. For example, in the last scenario that we talked about, so okhane when the sister said that thik ache, you can have a rent for say rupees 30,000, and 30,000 rent was payable, it was an okay rent to pay for the brother. So they agreed. Now let's say she said that okay, you don't have to pay anything. Maybe the brother would have felt bad, thinking je ha eta to amake charity korche, ami charity চাই না, আমি দানে চাই না জিনিসটা। That could have gone wrong. If she would have said that you have to pay 50,000 because that's what the rent is of such a property in Delhi, then maybe it wouldn't have been possible for him that I can't pay 50,000 right away. So evaluating the option is also very, very, very important. Okay, that whether the option is actually feasible, whether it is practical, or they will all end up in the court saying that this is not practical, or the person is not following, and this is how it's going wrong. Okay, so that is also very important. And then of course settlement and non-settlement. This is like the end of the process of mediation. Now, this is one particular form of mediation process which has been laid down. This is more of a financial mediation process. Wentworth did this, and it's called the Wentworth mediation process. So you have to make an informed decision. You have to evaluate if mediation is appropriate. As I said, you have to understand if mediation is appropriate. If it's a criminal case like a murder, you can't say, okay, the victim's family said that, pay me this much and you are good to go. And you can murder somebody, pay the family, and the family said, okay, the murderer said, okay, it's a settled matter, doesn't need to go to the court. No, it doesn't work like that. Okay. So that's not an appropriate case for mediation. You cannot do that. Unfortunately, it does so happen in our country. A lot of times it happens that if there's a sexual harassment case, they pay the victim's family and, you know, everything is a hush hush. I personally don't think that's a very great way, but a lot of people also think that in rural areas where women are much disrespected and are not, you know, kept at equal footing with men, if, you know, somebody has a sexual harassment against somebody and they get married to the person, it at least saves the women's dignity, and that is better than running up to the court and, you know, getting the person, because ultimately the victim is not getting helped in any manner. That is also a way of thinking. I'm not very sure how much I side with it, but yes, that is also another way. But yes, you have to obviously evaluate if the mediation is an appropriate thing. Then you sign a mediation agreement. Now, since we are talking about financial, so it is very important to sign a mediation agreement, because if it is only talking about corporate mediation and where we are talking about money and finances, and if there's a contractual thing or something like that, a signed agreement is very important, that, okay, we are settling for this and we will mediate and we will try. If the mediation doesn't work, it doesn't work. Then you prepare. You discuss your priorities and concern, you gather the financial data, you should have all the evidence and everything that you want to talk about right there. You can't expect the other person to believe that I say, okay, my company is making a profit of 10 crores a year. You have to show it in pen and paper, okay? You have to have the data. You can't just, you know, like expect the other party to believe that, okay, whatever you say is right. Then prepare financial exhibits. Then you have the mediation sessions where you have financial discussions, parenting discussions, other discussions, whatever discussions you have. And then you talk about the financial part of it. You basically draw an understanding of how it's going to be in terms of finance and other matters. And then you finalize. And then you can file it to the court saying that this is our mediation agreement and please pass this as a decree. So then the court can pass it as an order and then it follows. So it's a good process. It's a very brilliant process if we can all take in. So I would just repeat myself again. The process of mediation is about building trust, number 1. Triage and plan, number 2. Educate and inform clients is number 3. Reaching a consensus is number 4, and bringing closure. Okay. Now, when we talk about the process of mediation, when we get into the process of mediation, there are a couple of things that needs to be understood. So, for example, I'm in a mediation room and I am party A, and the other party with whom I have a dispute is party B. So, and party B, basically the understanding is party B has accidentally hit my car with her cycle and it has damaged my car. So let's say this is the dispute. Okay. So I get into the mediation room and I say that, okay, you damaged my car and you created a loss for 30,000. I have to repair my car and I want the money. Okay, this is what I say. Now, when I say this, I am actually blaming the other person, A, and I am more fixed on the understanding of my position, that this is what I want and this is what you will give me. Okay, this is my understanding. Now, as a mediator, if I am the mediator there, what I will do is I will immediately move from A to B and I'll say what A means to say is that A's car was damaged and there's an approximate estimate of 30,000 from the mechanic, which A expects to be taken care of. Now, when I say this, I am shifting the focus from the blaming on B to the damage on A. Now, what is the position that A is? Hello. I think somebody is on unmute. Can you please mute yourself? I see a raised hand. So do you have any doubt? Okay. If any of you have any queries or do not understand something that I'm saying, or if I'm going too fast, please unmute yourself and let me know, okay? Because I am not sharing the screen with everybody's picture. I'm just looking at the PPT, so I'm unable to see everybody on screen. So kindly do so. Please let me know, unmute yourself and let me know if there's any query. Okay, so coming back to reframing. So what I'm doing is I'm shifting. So now let's say here, A's position is, I want 30,000 rupees from B. This is the position of A. Now, what is the interest of A? A's interest is, A's car is damaged. A just wants that damage to be repaired. Okay. Now, let's say B actually has a brother who is a car mechanic. So instead of paying 30,000 rupees to A, if B takes the car to his brother and gets it repaired, he might be able to just get it done in 10,000 rupees, which is something that B can pay. Right? So when something like this happens, it actually gets resolved. So reframing is basically putting the words in a different manner to move A, the blame, to stop the understanding of blame of the other party, and B, to move from position to interest. Okay, so as I said here, it's crucial to understand that each person or group has multiple interests. Some will overlap and others will conflict. When we focus on positions, there is only one solution. As I said in the example, the position is A wants 30,000 rupees. So solution is B will pay 30,000 rupees. It is very simple, right? But that is not what is going to happen. However, when we focus on interests, you can discover multiple solutions. Now, what is the interest of A? A wants his car repaired. Now that can be done by B. That is really how you can start to make a breakthrough in helping people find common ground. Those multiple solutions might meet one or more interests of different parties. Take a few minutes. Well, there was a video, I was unable to get it through, but basically, I can tell you this is what it meant. Now, when reframing, we are trying to help people move from their fixed, intransigent positions to discovering and articulating their interest. Okay, so we move people from their fixed position of blame to the position of their interest. Now, position and interest, let's talk a bit more detail in it. So, as I would want to mention, reframing is a very, very important part of mediation. So, if you are a mediator, reframing or rephrasing, like, jumbling up the sentence and, rephrasing the sentence is a very, very crucial part. And you have to do it like at least 10 to 12 times in a mediation at basic minimum level. So if it's a 1 hour mediation, you should be able to rephrase like 5 to 6 sentences somewhere down the lane. Okay, it is very important. It takes a lot of time, because suddenly coming in and butting and moving the word from I blame you and you did this to me to how A got hurt, that's going to take some practice and a lot of time, but this is very important and it cannot be missed. So I would want to suggest that anybody and everybody here should, since all of you are taking this mediation training, I think all of you should practice more of reframing and rephrasing. It's a very integral part of mediation. Okay, getting back to position and interest. Now, what is the position? The solution you have decided upon. That is the one solution. In the example we took before, that was like pay 30,000 rupees. One solution, one position here. Interest, the underlying motivations, the hopes, the concerns, the desires, the worries that led you to your position, which can have multiple solutions. In the previous example, getting the car recovered or repaired. Now, the moment you say, I want my car repaired, you have like, okay, we can take you to, instead of paying 30,000, why don't we bring a mechanic and get it done? Or I am a mechanic and I can fix your car. Or I have a mechanic friend who will fix your car for free. Or I have a brother or a sister who can do it for 10,000, let's say. So all of that, okay? So interests motivate people. They are silent motivators behind the hubbub of position. Your position is something you have decided upon. Your interests are what cause you to decide. Behind a post position lies shared and compatible interests as well as conflicting ones. There are particular kinds of questions you can ask that will help people articulate their interests. So as a mediator, your job or your task is to basically poke people and make them talk about their interest rather than positions. Okay, so don't ask for a proposed solution. Instead, try and find out what they care about. You shouldn't say, like, you as a mediator, you shouldn't say, okay, I understand your problem, now what is it that you suggest as a solution? Okay, you should never do that. You might feel or think that that's a way to go ahead, but no, that's not how. If people knew the solutions, they wouldn't be sitting there. Okay, mediation is a way to find solution, and you have to guide them through it rather than just popping that up in front of them. Now I'll give you my favorite example and the favorite story. It's called the orange story. It is about a brother and a sister, and suddenly one afternoon they wanted to have an orange, and at that point of time in their house they just had one orange. So both of them started fighting over that one orange that was there. So they were fighting and bickering over it and something like that. So the father walked in and he saw that something was wrong between his children. So he asked them, "Ki byapar, tumra jhagda korcho keno?" So one of them said, "I want the orange." And the other said too, "No, I want the orange." So the father understood that ওরা দুজনেই ওই কমলা লেবুটা চাইছে, আর একটাই কমলা লেবু আছে বাড়িতে, বাইরে থেকে নিয়ে আসারও কোনো সম্ভাবনা নেই এখন দুপুরবেলায়। তো সে কি করে, কমলা লেবুটাকে মাঝখান দিয়ে ভাগ করে দুজনকে অর্ধেক কমলা লেবুটা দিয়ে দেয়। And then he goes away thinking that, okay, he has resolved the issue. There's one orange, both of them want the orange, you divide it in half and you give it to them. It's very simple. And he goes away. But the brother and sister are not happy, because they wanted the complete orange. They didn't get what they wanted. So they were still sad and they were not talking to each other. Otherwise, they were a very friendly duo. So they would always sit and chat, giggle and play together. But they were just sitting, sad and, not talking to each other. So the mother walked in and she sensed some sort of a tension in the air. So she asked that, "Ki byapar, tumra erokom gombhir hoye boshe acho, kotha bolcho na, khelcho na, ki byapar?" So the sister said, "I wanted an orange and now I have only half of it because the other half was given to the brother." So she said, "And what about you?" She asked the brother. So brother said, "Hey, amaro puro orange ta chailo kintu amake to deyni, ami অর্ধেকটাই পেয়েছি, so I'm sad." So the mother understood that both the children wanted the orange, but they now only have half, so they are sad. What she does next is she asks them, "Why do you want the orange?" So then the daughter says, "I want the orange because I wanted to make orange marmalade. It's sort of a jam. I wanted to make, let's say, orange jam." She said, "Okay." And she asked the brother that, "But why did you want the orange?" He said, "Because I wanted to drink orange juice." So she understood very quick what both of them want. Now she has actually and successfully moved them from position of "I want orange" to "I want orange to make marmalade" and "I want orange to make orange juice." Now the interest is orange juice and orange jam. So what she does, she takes both the halves of the orange, she gives the entire peel to the sister because she wants to make jam, and jam can be made by orange peel. And she takes the internal pulp and gives the whole pulp to the brother because he wants to have juice, and the juice can be made through pulp. And she does that, and now both of them are happy. So the sister is now happily making orange jam, and the brother is now happily drinking orange juice. So she asked the right question at the right time and pointed that instead of saying, I want orange, if you can move them. So I want orange because I want to make orange jam. You instantly know to make orange jam, you need the orange cover and you don't need the pulp. So if the entire orange was given to the sister, she would have taken the peel and thrown the pulp. And likewise, if that would have been given to the brother, he would have taken the pulp and thrown the peel. So now instead, both of them have what they actually want. This is a very perfect example. And I can assure you real life situations are not even as close to this. But it is also true, no matter however complex it is very, very easy. Once you start talking, once you start moving the parties from their position to interest, once you make them talk about what they really want rather than what is it they think they need. Okay, so it is very important. Now, how do you do that? You do that by reframing or rephrasing a lot of times, and you do that by asking the right questions. Okay, so this is another example that I have. So basically, there are two men who are sitting in a library, and one wants the window open and the other wants it closed. I think it happens to a lot of us. যখন আমরা বাসে যাই বা কোনো একটা পাবলিক ট্রান্সপোর্টে যাই বা ধরুন লাইব্রেরিতেই বসে আছি, একজনকে বলবে যে জানালাটা খোলা রাখুন, একজনকে বলবে জানালাটা বন্ধ করুন। এই ঝামেলাটা আমরা মোটামুটি সবাই কখনো না কখনো জীবনে ফেস করেছি। So this is something like that. একজন বললেন যে জানলা খোলা রাখুন, আরেকজন বললেন না না জানলা বন্ধ। এরকম করে ওরা অনেকক্ষণ ধরে এই নিয়ে ঝামেলা করছে। তো জানলাটাকে আধা খুললো, কখনো জানলাটাকে পুরো খুললো, কখনো একটু খুলে দেখলো। যাই হোক, কোনোভাবেই মানে জিনিসটা মিটছে না, কারণ না জানলা খোলা হচ্ছে না জানলা বন্ধ করা হচ্ছে। এবার কি হলো, the librarian walks in and she sees them quarreling. Obviously লাইব্রেরিতে ঝগড়া করাটা একদমই মানায় না। তখন সে জিজ্ঞেস করে যে আপনারা কেন ঝগড়া করছেন? তো তখন বলে যে একজন বলে যে আমি জানলাটা খোলা রাখতে চাই, আরেকজন বলে যে আমি জানলাটা বন্ধ করতে চাই। তখন সে জিজ্ঞেস করে কিন্তু কেন? আপনি জানলাটা খুলতে চান কেন এবং আপনি জানলাটা বন্ধ করতে চান কেন? তখন একজন বলে যে আমি জানলাটা বন্ধ করতে চাই কারণ আমার এখানে অনেকগুলো ডকুমেন্ট রাখা আছে এবং জানলাটা খুলে দিলে হাওয়ায় আমার ডকুমেন্টগুলো উড়ে যাবে। আর অন্যজন বলেন যে আমার আসলে কোনো বন্ধ জায়গায় আমার প্রচন্ড নিঃশ্বাস নিতে অসুবিধা হয়, তো তাই জন্যে I want the window open because I wanted fresh air to come in. ঠিক আছে? Now, once the librarian understood their interest rather than their position, because position was very strict. One said window open, another said window closed. How do you solve that? If you are just talking about position, how do you solve that? You might have to do a toss with a coin, say, okay, let's see, whoever wins gets the thing. But now that you have moved them from their position to interest, you understand why both of them want that, and maybe you can actually solve the why without getting into what they want exactly. What she does is she keeps that window open and she opens another window at another corner of the library to get the fresh air in. Another way could have been that she could have put up a paperweight, because in library you do have a lot of paperweights. So you take up a paperweight and you put it on the paper pile that the person has so that the paper doesn't flow, and she opens that window. Right? So when we talk about this disagreement about opening a window, you have a person A whose position is open window and person B closed window. You can't solve this because there's only going to be one solution to it. Now the interest is person A wants fresh air. B does not want a air draft, so that the papers and documents are in place. It doesn't flow away. Now, what is the solution? You open a window in the next room so that the air comes in. Okay, or another solution could be you put a paperweight so that the air draft doesn't, damages the paper pile or swifts away. So this is what we need to do when we are in the process of mediation. Okay. Often people take positions because they believe that the position addresses their interests. Rarely is that position the only way to address their interests. Sometimes their position conflicts with your interest. That doesn't mean there isn't a position that can address both parties' interests. Your job as a mediator is to drive parties towards shifting from positions to find solutions by bringing both parties' interests. Essentially, what you want to do is ask why, but without using the exact word. You know, if somebody says, let's go back to that example that we took, that between A and B, B damaged A's car. So A said that I want 30,000 rupees. And if the mediator asks why, then A will probably get very furious, you know. What do you mean by why? I want 30,000 because he damaged my car. He has to pay 30,000. So even if you're asking why do you want that, you have to be like very polite and you have to like ask it at the right time in the right manner and method. You can't just be very like blaming sort of a way. Okay, so you have to be very careful. I mean, if I have to say honestly, mediation এ হয়তো মনে হবে যে কিছুই তো করার নেই মিডিয়েশনে, কি আর করবে, না মিডিয়েটর ডিসাইড করে, না মিডিয়েটর কিছু বলে, না মিডিয়েটরের কোনো ইয়ে আছে, কি বা করে মিডিয়েটর? It seems like that, trust me, but it is a very, very difficult job. Not doing anything but controlling the entire process, not deciding but getting the parties into their zone, and your only weapon is your words. Okay, you can't give your knowledge out. You can't say that, okay, I know this is the law, you are right, you're wrong. You know, you don't have any references, you don't have any law to back you up as your weapon or, you know, as your defense or anything. The only thing that you have are your words and your body language and your demeanor and all of that. So it is very important, it is very tricky, and it's just that how it is. Okay. So it's a very interesting and a very, very difficult job. Well, so when you ask something like this, it isn't an accusatory kind of question, rather you're probing for needs, hopes, fears, and desires. So try and understand generally what happens behind what generally are the interests of the people. I'll just use a highlighter. So when you have position, it's mostly like what they want. But what is an interest is basically what they need, what are their hopes, what are their fears, and their desires. These are the basic things, mainly. There could be other emotions as well. But if you focus on finding out these couple of emotions, you would be able to find out the interest. Okay. Okay. Now, position versus interest. Position, what they say they want. Interest is why they want it. Sorry. Now, positions are surface statements of where a person or organization stands and rarely provide insight into underlying motivations, values, or incentives. Interests, on the other hand, interests are a party's underlying reasons, values, or motivations. Interests explain why someone takes a certain position. Now, what is the position example? Union demands a 5-year contract. Let's say this is a position and this is what it is. Now, what is the interest behind it? Union wants time for workers to retool their skills before plant closings are implemented. So basically, I'll explain this example further. Let's say there's a factory and everybody knows it's going to shut in the coming 3 years. But the union is demanding that 5 years you have to keep us at work. Now the company will say, no, we can't keep you 5 years. Now, what is basically the interest? They just don't want to, you know, lose their skill set and everything, before the closing starts. What could be done is maybe they could be all assigned to a couple of other workshops in the last 2 years after the shutdown of the factory or something, so that they keep working and they have their skills. So it is something like this. Okay, so the more you talk about why and what is behind what's happening, and your emotions, this is basically the emotion of fear that we just referred. Okay, so there's a fear of losing out. So sometimes you have desire, sometimes you have some other emotion, but it is always some sort of an emotion which is sort of triggering factor for what the position is for the person. Now, a couple of position and interest statements. Position is, for example, start a month early. Now, interest is you want the person to start a month early because you want the project to be finished on time. Now, position, what people say they want. Interest is why they want it, okay, like the underlying motivations. Position is what are their demands. Concern is what the interest is. Position is things you or they say you will or won't do. Interest is the fear and aspirations. Position is the subjective ones, and interest is the objective needs. Okay, so this is, I will tell you, I mean, if you understand the difference between position and interest, and if you can drive people from position to interest, 90% of your mediator's task is done. Okay, 90% of the task is done, because this is one of the most important and the preliminary things that needs to be done. Once you have the interest of both the parties on table, you start a discussion, they will get into discussion, you will come down to creative ideas, and you will eventually find a way out. Now, the shift from position to interest. Now, a couple of examples that I have that you can ask people when you're trying to make them shift from position to interest. For example, it's like, what concerns, worries, upsets, bothers, or frustrates you about the particular situation? Okay, so what are your concerns or worries? So if, for example, if I keep talking about the one example that we have taken as a guideline, the car damage one. So what are your worries about the damaged car? My worry is it was a new car, and I saved up a lot of money to buy that car, and now it's damaged. It's really painful for me to see. Okay, and it's something I feared the most, and it happened. So that is what is upsetting for me. What is your basic concern in wanting the 30,000 rupees, for example, say? Because I want my car to be repaired. What do you fear might happen if the money is not paid? I will have to pay more money, which I don't have, and my car will remain damaged. What do you hope will happen if 30,000 is paid? I will get my car repaired. Okay, then you can ask questions like, what do you really care about? What is important to you about? What will your solution help you accomplish? What leads you to believe that your solution will get at what you need? So these are all these questions which will help someone shift from position to interest. Just a moment. Okay. Now, let us talk about the steps of mediation. Now, the first step, I'm not talking about the stages yet. I'm just talking about the steps in general and as a whole. Now, what is the step? Step one is convening the mediation process. Now, convening of mediation is often the most difficult and challenging part of the process, and it involves a lot of procedures. I have taken a couple of examples based on the Indian scenario. I think it's going to be very similar for Bangladesh as well, considering we almost follow the same CPC, the Code of Civil Procedure. So I think it's going to be pretty similar. So number one way of convening a process is reference to ADR by the court. The court is required to direct the parties to opt for any of the 5 modes of ADR and to refer a case for arbitration, conciliation, judicial settlement, lok adalat, or mediation under Section 89 and Order 10 Rule 1A of the CPC. Okay, so the court will refer you to any one of the mediation format, any one of the ADR forms. Okay, the court must consider the option exercised by the parties and sustainability of the particular case for the option chosen. The judge making the reference, known as the referral judge, is required to acquaint himself with the facts and the nature of the dispute. So it's basically the judge making sure that the case is suitable and apt for the particular process that they are referring to, and the judge is also known as the referral judge. So for example, a referral judge referred you to mediation, say under me. So after the mediation, what happens is we have, let's say, and we are lucky enough to have a mediated settlement. So once that mediated settlement happens, you can take the settlement agreement to the court, and the court will now pass it as a decree. Okay, so that happens. Now, this appropriate stage for making the reference in civil cases is after the completion of pleadings and before framing the issues. This is pertinent to India. I'm not sure how we are following in Bangladesh, but I think it would be similar. While in cases pertaining to family law, the appropriate time for making the reference would be immediately after the service of notice on the respondent and before filing of the objections or written statements by the respondent. Even if the court did not refer the cases to ADR at this time, nothing prevents it from referring to it at a later stage. Okay. As a blanket rule, I can tell you that the court can actually, if the parties request, even before the final judgment, if the parties request that we want to go for ADR, the court can refer it to ADR if the court thinks it is fit and appropriate to do so. So the court can refer at any given stage. Now, preparation of mediation, the referral judge then has a crucial job of bringing the parties together, motivating them to resolve their disputes through mediation. This involves finding the reasons for any disinclination on behalf of the parties to enter into mediation, along with explaining the concept, process, and advantages of mediation. While the consent of the parties is required for mediation, the court may also apply external pressure to induce parties to enter mediation. A lot of times I have witnessed it in family courts, at least the judge himself comes around and says that if you're going to come here, it's okay. I am sitting here. I don't mind doing this, but you'll have to keep coming here for the next 3 to 4 years. If you just want to get it settled in, a couple of days or months, I think you should go and see a mediator. Otherwise, you can come here. I'm just here. I've literally witnessed this myself. And that's actually really nice and very motivating, because then the parties get scared. So since we are having all the sitting judges here, I think you can probably do something like that. You can just tell them that, if you think they are much more focused on litigation and they don't want to get into mediation, you can probably probe them like this, saying that it's okay, you can come here and you can keep coming here for as many years as you want. But if you really want it resolved before, let's say, your son or daughter gives the board exam, I think you can try mediation. So it was very clever of the judge to do that. He was a sitting judge in Calcutta High Court. So that was very interesting. Anyways, while the consent of the parties is required for mediation, the court can also apply external pressure. As I said, you can sort of like give them a nudge or pinch them or tell them that try this or something like that. Okay. Referral order. A referral order issued by the referral judge initiates the process of mediation and is the foundation of court-referred mediation. An ideal referral order contains details like name of the referral judge, case number of the parties. I think this is more sort of specific to India, but when a referral judge refers a case to any format of alternative dispute resolution, they have to have this reference order, and the order has to have details of everything. Okay, the court details, the judge details, the order, case order details, and everything. And also, if the parties settle well and good, if the parties don't settle, they have to sort of the mediator has to sort of write down a feedback saying that a settlement could not be achieved because the parties, say the party A wasn't willing to settle or something like that. So of course, you might feel that might be held up against you in the court of law. That's not true. Yes, the judge might on a personal note say, why did you not settle? This would have been much easier, but that's about it. That's not going to really affect your case. So it doesn't happen in practice. Now, step 2 is the initiation of mediation process. Initiation is basically the welcome. We are going to discuss these at length while discussing stages of mediation, but since we are discussing a lot of the process. So initiation of the mediation process. So initiation is basically welcoming. You meet the mediator, you talk about your background, you talk about your facts, and then you have the opening statement, which is like, you are part of the story, and you have to explain everything, and you have to tell what it is that is there. And the opening statement is generally done by the mediator first, followed by either of the parties first, and then the other. And if you are actually a very good mediator, you will actually ask both the parties that who do you think should go first, instead of choosing one yourself. Because if you choose, say, for example, I'm a mediator and there's a dispute between A and B, and I just randomly say, okay, why don't we have ladies first, and A, why don't you speak? So immediately the party B might feel that I am biased towards ladies. Okay. So this is something you have to be very, very, very careful about. Always treat the parties equally, and be very vigilant about your body language, your words, how you're behaving with either of them, because at no point would you want to give an impression that you're partial towards either of them. Okay. Then setting the agenda. Setting the agenda is very important. Setting the agenda is an important duty imparted on the mediator in order to shed clarity on the mediation proceedings and remove vagueness. This is basically like, if you, in some countries they practice, I personally practice this as well. I generally take a blank sheet or a blank note. You can also have a whiteboard if you have that in your mediation room, or in any room where you're practicing mediation. You can sort of write down the issues there. You say that, okay, let's discuss this and let's point out the issue. So do you think, you write down issue 1. So do you think this issue is valid for both of them? For example, if you have a divorce cases I was discussing. So for example, divorce case, the custody of the child, that is an issue. No, that is not an issue, because both of them want and both of them know that the mother is going to have. So that is not an issue. So number 2, maintenance, is this? No, maintenance for the wife is not an issue. Maintenance of the daughter, yes, that is an issue. How much is going to be the maintenance? What we're going to talk about, that A. Okay, that is an issue that is common to both, that we write down. So now we have clarity. We are not going to discuss about maintenance of the wife or who is going to have the custody of the child. We are not going to discuss that. It's very clear from. So setting an agenda is very important, and it is actually a mediator's task to do that. Number B, for that is, it involves setting down the order in which negotiation is to proceed, and given the party standards using which they can individually evaluate. Also, when you have all these issues in place, you need to sort of place them one by one. So we will discuss issue number one first, number 3 then, number 4, or you name it like that. Okay, 1, 2, 3, 4. This is how we are going to number, because this is how we are going to discuss. A lot of times in mediation, you might come down to an issue which is not getting resolved. If it's getting stuck for too long, what you can do is you can say, okay, since we are unable to resolve this issue right away, let's keep this issue at hold. Why don't we discuss the other issues first and then come back to this at the end of the mediation session? That also works a lot of times. Okay, so you move on to other issues, you resolve those, and then you come back to this current issue at hand. Then you have the mediator may mention the time and venues for the negotiation sessions along with the issues before the parties to be discussed subsequently. Okay, setting the agenda. Now, facilitation of negotiation and generation of options. So this is done basically through the 2 sessions that we have. We're going to discuss it further in the stages. It's basically joint session where all the parties sit together and discuss. And you have separate sessions, which is the private caucus. Joint session is where you actually create options. Okay, you create and you talk about different options that you have. Private session is where the mediator gathers more information to understand what is going to be the scope of agreement. Okay, and then reaching a settlement. Of course, if you are lucky to have mediated with a disputant party who is a good mediation practitioner as well, then you go ahead and settle. Let me tell you one more thing. A lot of times, if you are mediating or you are sending things for mediation, you might feel disheartened that, okay, we didn't settle through mediation and it was not a successful mediation. Now, settlement through mediation is never a benchmark for success of mediation. Okay, only if parties settle, the mediation has succeeded. That's not true. When you're sitting in a mediation room, when you're discussing that with the person you're fighting so much outside, you end up discussing a lot of things which are more pivotal. Okay, and through those discussions, so for example, if you have like 5 issues and out of which you settled 2 or 3 and you couldn't settle the rest 2, so you couldn't draw a settlement agreement. You can also draw a partial settlement agreement saying, okay, we have resolved these 2 issues, these 2 are settled here through this agreement, the next 2 issues can be taken to the court because mediation is unable to settle that. Even if you don't do that in written terms, you do understand that when you actually are in a mediation setup and you talk about your options and talk about your interests, you move from your position, you also start seeing what the other party is and what the other party is wanting and everything. It does get better, okay? It definitely does get better. It is never that people walk out of mediation room without achieving or having anything at all, okay? Unless of course the one of the parties just did not want to mediate and was just sitting there blank because they were obliged to do so because the court said you have to go for mediation. Other than that, something is always achieved out of mediation sessions. Okay, now reaching a settlement by helping parties to understand the reality of the situation and give up rigid options. The mediator can conduct as many sessions and okay, so one more understanding is when parties reach the settlement, the mediator does not decide the settlement terms. The parties decide the settlement terms. The mediator just helps them draw that and has nothing to do with what the final settlement agreement is and is supposed to be done. But as a mediator, what you need to do and should be doing is you should check the practicality of the settlement terms. Okay, so by practicality I mean, so for example, this A and B case where B's cycle had hit A's card. So for example, the settlement comes down that okay, so B will pay 10,000 to A after 1 month. Now this is not practical. What if B doesn't pay that money after 1 month? What will A do? Will come again for mediation or will go to court. So that is not practical. Okay, so for example, then you say that okay, so how do we do? B doesn't have money, so you have to find out some options. So for example, you can say that okay, B, why don't you write down a post dated check to A after a month, so that when A goes to your bank and puts the check after 1 month, he gets the money because then you have the money and that check can be written right there in the mediation room. Okay, so it doesn't have to be that quick and like on spot, but whatever you decide as a settlement agreement point should be practical. Okay, it shouldn't be like too much vague and like okay, I'll pay you up after 30 years and that can't be a settlement agreement because you know it's never going to settle because after 30 years you don't know where you are going to be or the parties are going to be. So you have to understand and always judge the practicality of what you are giving as a solution in the settlement agreement. That is the job of a mediator, to see whether the points of settlement agreement are practical and achievable. And yeah, and then you have the closing. Well, there is no fixed process for closing per se, but every country actually has a different way of doing it. But in general, once the terms of the settlement have been agreed and you know the mediator orally confirms and you sign that, and if you have a referral judge, you can take it to the referral judge and the judge can pass it on as a decree. And yeah, that's mostly what is done. And also one other thing, if the settlement is not reached, everything is basically confidential. You can't send the mediation documents back to the court saying that okay, this is why it didn't settle and all that. You can't blame or accuse, or you can't use anything in the mediation room as an evidence or witness against any of the parties. And the mediator can never be called upon as a witness, even as a character witness or whatever, you know, in the court of law. So everything that happens in the mediation room is completely confidential and nothing can be revealed or taken up from there. Now, as a summary of the process of mediation, you have to basically understand that the beginning is introductory remarks, then you have the statement of the problems by the parties, you have information gathering time, You have identification of the problems, you have bargaining and generating options, and you have reaching an agreement. Now, what are the do's and don'ts of a mediating lawyer? So if you are a lawyer who practices mediation, by that I mean you basically assist your clients into the mediation room and guide through them, and you participate in their mediations. If you are a lawyer, these are your do's and don'ts. Always remember to treat the mediator kindly. A lot of times I have witnessed this personally as well. Lawyers come in and they think too high of themselves. They think just because the mediator is sitting there and not giving any legal or throwing off any legal knowledge means the mediator is probably dumb or doesn't understand, or they try to overpower the mediator. That is something which is absolutely rude, and you cannot do that. If that's something like that happens, mediator can always walk out of the room saying that I will not mediate. So the lawyers have to be more vigilant and be more kind and respectful towards mediators. You have to understand the mediator's job is way more tougher than a lawyer's job. And trust me when I say this, it is. Always prepare a mediation summary for the mediator in advance of the mediation. Your clients will appreciate it. You will be better organized and the mediation will be more effective. Don't use the mediator as an errand boy to shuffle back and forth with offers and counter offers. Give the mediator the reasons and rationale for offers. A lot of times it does so happen, specifically in financial mediations when this is happening, specifically in deal mediation when we are trying to, crack a deal between two parties. For example, there's a hospital, and on the other end, there is this pharmaceutical company who are going to supply medicines. And we are just talking about the final balance sheet and how much fund can the hospital give and how much the pharmaceutical company can provide for that particular balance or something like that. So we are trying to, create a deal there. In such cases, a lot of times it does so happen that the lawyer will give you, okay, we are ready to pay, 8 lakh rupees. So the mediator will go and say, okay, they said that they are okay to pay 8 lakh rupees. So this party says, but how 8 lakh? 8 lakh is not appropriate. This is what is our demand and it cannot be less than 12 lakh. It is not possible. So I come back as a mediator and say, oh, they said it's not possible under 12 lakh. Okay, we'll pay 8.5. That is the last. So this lawyer is actually not telling me why are they. So if the lawyer tells me, see, we are okay to pay 8.5 lakhs because this is our budget, this is what has been allocated, and we have the rest 2 lakhs, which is an emergency miscellaneous one in case any of the machinery fails or anything goes wrong or something happens. So we have to keep this saved. Okay, we can't give this up. Now, when you give me the reasons, I understand you trust me as a mediator, and then I can go ahead and say that see, it is not possible because they have to save that up for any emergency reason or something like that. And then they might say, okay, what we can do is, so let's keep this 2 lakh on hold. And by the end of the year, if they haven't used any emergency funds by then, they can actually transfer and we can adjust it in the next year. So this is more, how do I say, more appropriate. And this is more rather than just having mediator as an errand boy to, sort of shuffle back and forth and go say, okay, I give you 10. Okay, no, I give you 12. No, I can only give you 9.5 and something like this. This is not fair. Okay, you can't use the mediator like a fool. Prepare your client for settlement in advance. As a lawyer, as a mediating lawyer, it is very, very important to let your client know that you should be able to settle here, because if you don't, going to the court is not going to be a very good option. If you are a lawyer who says that are nahi hoga settlement, so it's okay, no worries. কি হয়েছে যাতে সেটেলমেন্ট হবে না, তাহলে কোর্টে চলে যাবো, ওদেরকে তো এমনিতেই হারিয়ে দেবো কোর্টে, এসব সেটেল ফেটেল করার প্রয়োজন নেই. If you are a lawyer saying that, it's going to be very difficult and sad for your client. So as a mediating lawyer, you should prepare and you should encourage your parties to settle. You can tell them what are the pros and cons. You can sit with them and help them draft their best and worst alternative to this agreement. And, you can actually help them put things in perspective. Always put your settlement agreements in writing and leave sufficient time to negotiate during process. Don't forget to include attorney's fees. This is very important as a lawyer. If you are trying to create a settlement agreement, so if you have a mediation where the lawyers of both the parties are sitting and you're the mediator, you can actually depend on both the lawyers to draft the settlement agreement for the parties. And you can just check at the end that it is actually sufficing what both the parties have agreed to and the points are practical. So while doing so, as a mediating lawyer, it is suggested that you also include your advocate fee. Because then once this is drafted and later on you say that you give me the advocate fee, then the party will say, why didn't you put it in there? I would have, in my claim of the other party, I would have asked that as well, the advocate fee. So all that you should put it there in the agreement. Consider getting a cost deposit from a client for mediation upfront. Now, when you have lawyers involved in a mediation, generally, it is the lawyers who approach the mediator because they are more well informed than the client. If you're doing something like that with a mediator, I think you should have a deposit as well for the mediator, because a lot of times a mediator cannot run behind clients asking for money. Okay, it doesn't work that way. And the mediator probably agreed to mediating because they knew you personally as a lawyer. Okay, so it's good to have an upfront payment from both the parties, so that the mediator and your face gets saved, and nobody's in an embarrassing situation. Remember to let your client talk during mediation. This is very important. We lawyers most often forget that the other parties who are actually the disputants should be the ones speaking rather than we. So it is very, very, very important to let the parties speak. Lawyers have a very bad habit of interfering and speaking in between and stopping others to speak. Do not do that. As a mediating lawyer, you should know this right from the beginning, that you will speak less and your client will speak more, much unlike a regular lawyer. Try to resolve all contingencies before mediating. Now, what we mean by that is, for example, if you're coming for a mediation, for example, that car damage one, I think it's going to be a very universal example for us throughout the day. So in that, for example, I haven't had an estimate from a mechanic. The mechanic is supposed to give me an estimate by 2 p.m. and I scheduled a meeting at 10 a.m. in the morning. So that's not fair, because now I don't even have an estimate. I'm just saying approximately, how will I mediate? So wait for it. Rather than that, say that, okay, we are getting an estimate at 2, we can do it from 3, or we can do it tomorrow, rather than just, scheduling it. So you have to clear all the contingencies before mediating. And have all necessary documents. Do not expect the other party to just believe on whatever you're saying. Okay, so keep all the documents and evidences ready so that you can present it, and the other party knows that, okay, yes, this is true and it's documented and there is evidence. Okay. Oh, also, while showing evidence, it shouldn't come across as more blameworthy, that you have done this to me, see, I have proof. It shouldn't be like that. Okay, it should be more like, this is what the estimate is and this is what the document is, or this is how much the damage should cost, this is what I have talked to an expert, and stuff like that. Okay, rather than being blamishly close, it should more be like presenting with facts. Okay, now mediation do's and don'ts. Now, mediation do's and don'ts, this stands for mediator, of course, and also for the clients. In general, I mean, so this stands for anybody as in general. Stay at it. Both sides came to find a deal. Mediation takes work from all sides to get a deal. Listen to other side and be honest in your replies. Don't just walk away. Okay, you cannot be impatient in a mediation. Trust me. There has been mediations which were supposed to be only 2 hours, and it took from 2 to 7, 8 hours. And so we were basically doing a mock mediation for an international mediation competition and at a university, and we were trying to prepare for it. Okay, and then we had so there were 2 people who were doing a role play, and they were doing it brilliantly. Okay, they were like 2 clients, husband and wife. It was a family dispute and they were doing it brilliant. So it was, we sort of had put up on schedule for 2 hours, but the mediation kept on going and it went for like 6 hours or so, if I'm not wrong. We missed our lunch and we were late for like this high tea. And by the end, when we reached the end, they all, because the people who were doing the role play, they were so brilliant. They were acting so natural, and at the end they got back again to issue number 1. Okay, they were like, no, but since we can't resolve issue number 5, what's the point of issue number 1? We didn't resolve it at the first place. And they went back to that. Oh god, it was so straight to us, and the mediator almost like sort of gave up. The mediator was like, I can't do this anymore, you have again come back to the same issue. That was funny at that point because we were practicing and we just let it go. But when this happens in real life, it gets really clumsy and it gets really hard to concentrate and, just sit there. Even just sitting there is so difficult. But that's what the mediator is. And you have to like literally stay at it, and you have to listen, and you have to be like genuine. Okay, so you have to be very, very patient. Can you just give me a moment? I'll just mute my mic. I have somebody here. I'm so sorry. Actually, we have something happening at my family's end, and there are a lot of people at my place. So I just have to. Anyways, I'm sorry for taking the short break. Yeah, so what I was saying is you have to be very, very patient when you are sitting in the mediator's chair. It's going to be rigorous. It's going to be very, very, very strenuous, but you just have to, sort of stay at it and keep at it. Okay, you can't lose your patience at any given point. Secondly, you have to listen. Okay, listening is one of the most important skills in a mediation room. As a mediator, you have to like excel in it. You have to just, and it's very difficult, trust me. As a human being itself, we are not that patient. Our patience bracket, I think, is just 6 to 7 minutes, and then we lose our patience and our concentration, and then we again hop back to some other thought, and then we have to bring ourselves back. As a mediator, this is the most important and primary thing. You have to, even if you at one point understand that whatever they are saying is not going to help them at any point, but you have to still keep listening. Okay, and you have to listen carefully. And by listening, I mean you just are not hearing it, because hearing means I can also hear the sound or the noise on the road. I'm hearing because it's entering. So it's a biological thing. I'm going to hear. Listen means listening actively. And I'm sure you must have had or must be having any session on this listening, body skills and listening skills and all of this. These are very important as a mediator. So you have to listen. You have to listen with your full body. You have to listen with your expression and your brain and your entire self. Okay, you have to make the other person understand that you're listening. You have to be genuine. Talk about what you feel, what you need out of a deal. Okay, get feedback. Draw on the mediator's experience. A lot of times people fail to do that. A lot of time the clients or the lawyers who are in the room, they tend to think they are the experts. They forget that in a mediation room, if I have to honestly say, the only expert is the mediator, because it is only the mediator who understands and sees everything from a third point. The mediator has actually an eagle's eye. He gets the perspective of both the parties. He understands what both of them are trying to do and trying to get. So, if you are intelligent enough, you should talk to the mediator. And when you have your private caucuses or private sessions, you should talk and get feedback from your mediator. And think risk. When you're negotiating and when you're mediating, are the low point for risk. The next step may not be yours and you can lose control. So this is basically the Batna and Vatna scenario. You have to understand and weigh your risk, how much risk you're willing to take and you're willing to put up against something. So you have to be very, how do I say, you have to be very clear in your head, and you have to have a very neat picture drawn as to what is the risk you're willing to take if you do not settle through here. Because till you're in a mediation room or negotiating room, everything is still under your control. But once it goes out, it's not within your control. Someone else decides for you. Okay, so understand that very, very properly. Now, what are the don'ts? Do not lie in mediation. See, any which ways, mediation is a confidential process. Nobody is going to take anything out of that room and show it to the court. The mediator cannot be a witness. There's going to be no evidence out of mediation, so please do not lie. You will never win the scenario by lying. Okay, be honest. Yes, if you do not want to share or overshare, that is completely understandable, though we always encourage sharing, but do not lie. Okay. Lack of authority or lack authority. Now, lack authority is majorly for cases which are corporate in nature. For example, there's an employee dispute with the administration, upper administration. So a manager comes in and the employee comes in. And when by the time they are about to settle, the manager says, okay, let me talk to my VP because this is not within my domain. I don't have the authority to, approve this. So let me talk to my VP. Now, if something like that happens, the entire point of discussion is nil. Because now you will talk to your VP and the VP will say no or something or add another point. In such cases, it gets very difficult. So as a mediator, right before you start a mediation in such a scenario, you should be very clear that both of them actually have the authority to decide what they're here to decide. Okay, do not blame. Mediation is not about blaming. As I said earlier, moving from position to interest is one way of doing that. Blaming the other party is not going to help you. It's not going to encourage the other party to resolve or settle this for you or for themselves. It's just going to be a very blatant and a very painful process, and it's just going to be a blame cycle created. Okay. Pointing fingers rarely advances discussion. Review of facts and feelings is a normal part of mediation. However, you don't want to review to become a blame session. Take a future focus in talks. Where do you want to be? How can settlement correct the issue? Okay. Blame doesn't mean that you don't talk about what happened with you in the past or how you felt, but the point is you shouldn't just be there. Okay. You should talk about how you want your future. Use your phone. Yes, do not. Okay, this is something that I lay down as one of the ground rules in my mediation room. Nobody can use a cell phone, and that is it. Do not use a phone. Personal calls, any such calls, it is very, very intriguing. It is very disrespectful and it breaks the flow and it's not good. Okay, it's just not fair. Personal calls and business calls not relating to the matter at hand signal to everyone that you're not engaged in the process. Now, unfortunately, in our current scenario, we have all lost that. But I remember when I was in my school or college days and I would come home during vacations, and if I'm eating and I'm, looking at my phone, my parents would really scold me because that was against table manners. You can't be looking at phone. You're eating with everybody. You should concentrate on the food and the people you're sitting with. Likewise, if you're using a phone in a mediation room, it just shows that you're not completely involved in the mediation that's happening, and it's just there for the sake of it. Like you're physically there, not mentally present or participating. Another thing that you do not do in mediation is ignore emotions. You should never ignore emotions in mediations. Mediation is a place where you address emotions, you talk about emotions, you take care of emotions, you let the emotions flow. But of course, there has to be a pause. As a mediator, you have to be very vigilant and understanding where you need to put a pause or put a full stop. Okay. So if one party starts crying, you help them calm down. You let them cry first, but if they're crying and crying on and on and on, it's distracting the other party unnecessarily. At one point, you have to stop. You have to stop them, okay, as well. But you cannot say, okay, let's not talk about that. Let's not cry here. This is not the place. Let's not be sad here. Let's try and find solution. Don't do that, okay? Don't try to, suppress the emotion. You have to always recognize and handle the emotion, which is one of the most important things in mediation. So emotions are part of the human experience. Disputes are about how people experience them, not just the substantive matter at hand. In emotionally charged conflicts, you will rarely be able to have a conversation about the bare issue before you make some attempt to acknowledge and validate the emotions involved. So it's just basically like that. So do's and don'ts. Do's is stay at it, listen, be genuine, get feedback, think risk. Don'ts is don't lie. There shouldn't be a lack of authority. Do not blame. Do not use your phone, and do not ignore emotions. Now, how do you ensure that it is a bad mediation? You insist on keeping everything confidential from the other side and do not share your mediation statement with them. Sorry?
You proceed.
Does anyone have a doubt?
No, Madam Priyanka, no. You proceed.
Okay.
Carry on.
Okay, so you insult the other side, either purposely or inadvertently, or because you simply think they need to be told the truth about themselves. Like you just say, oh my God, you're such a liar. Oh my God, you're such a crybaby. Oh my God, you are like this or that. So you insult the other party, okay? Don't make arguments that will be most persuasive to opposing party. Instead, make arguments that would be most persuasive to a neutral party. Fail to consider that there is probably no they in the other room. Don't adequately prepare for the mediation. These are all the ways that you can ensure that you have a terrible mediation, okay? Rush to caucus rather than take full advantage of joint session. Okay, this is something that I will tell you. I've seen a lot of people think that private sessions are better with mediator, but just help me understand. Private sessions are only when they are needed, okay? It's not compulsory. It doesn't have to be there. You are in mediation because you want to talk to the other party in front of a mediator, not because you want to talk to a mediator. If you keep on just having private sessions with mediator, you might as well just get a counseling done for yourself rather than getting into a mediation. It doesn't make sense. Okay, so I have seen a lot of people think that having more and more private sessions and private caucuses is a great way to help mediate. I think that is a rather wrong understanding of what mediation is. I think the most you can make is that in a joint session. You can hardly have like one private session with a mediator and still be very successful at mediating a settlement. Okay, so it's not necessary and it's not important. Focus on negotiating a monetary amount to the exclusion of everything else. Okay, that is also terrible. You should never do that. You should not focus on for example, when I am talking about this car crash thing, if I say, okay, no, 30,000 is what I need. Now you tell me how much you can pay. I am not going to talk about anything else. If you do that, that's terrible. You're never going to make a settlement out of it. Okay. Start the monetary part of a negotiation too high or too low. As I said earlier, if you bet too high or too low, for example, you say if it's a 30,000 damage and you think that mediation is like that side hawkers ওই local বাজারে গিয়ে যেরকম দরদাম করা হয় সেরকম একটা কিছু, and you start off with saying instead of 30,000 you say I demand 80,000. You know the other party is never going to give you that. Okay, or let's say you start with okay, I demand 10,000. Like 10,000 is too less. You will not be able to make anything out of it. Okay, so you have to be in a regular range and not start too high or too low. Okay, fail to understand or don't explain to your clients that a first offer is a message and a bracket can be more important at midpoint. Okay, fail to ensure you have a team member who can work easily with numbers. If you are dealing with a financial issue, if you are in deal mediation, you have to have somebody who is good with numbers in the room. Otherwise, every time there's talk about number, you're going to call somebody, you're going to have to contact somebody, or you're going to take like 20 minutes to understand what the numbers are talking, and that is terrible. Okay, you have to have somebody with numbers in the room. Fight over disagreements on value rather than taking advantage of them. Sometimes it's good to have people who are not like you on the other end of the mediation table, and that way you can actually manipulate the situation and help yourself get into a settlement. Now, when I say manipulate and help yourself, I don't mean that you're going to cheat somebody or something like that, because you're not cheating here, you're not lying or doing anything. You're just trying to have a more civil settlement rather than going to court or fighting over it. Okay. Always assume that just because you have done something before, the other side will be convinced to do it, or refuse to do something because you haven't done it before. What it means by saying is, let's say the other party is not sharing at all, and I share and I share and I overshare, and I expect the other party to share as well because I'm sharing. That's not fair. Okay, you have to understand if the other party is willing to share or not, and how much are they willing to share. So you share maybe once and you see if the other party is responding well or not. If they're not, you don't need to, just because you are doing it doesn't mean the other party has to do it. Okay, there's no obligation. You can't complain to the mediator saying that, okay, I'm sharing so much, the other party is not sharing anything. Why don't you tell them to share? Doesn't work like that. Okay. These are a couple of ways to ensure bad mediation. So please do not do this to have a good mediation. Now, what are the general guidelines of mediation? Separate the people from the problem. As I said, issue from position to interest. Religion teaches us to hate the sin, not the sinner. If we view the problem as that which needs to be resolved rather than viewing someone holding a contrary viewpoint as a person to be defeated, the odds of a successful collaboration increase. One specific technique that works is to change the shape of the table rather than sitting opposite your opponents. So instead of having like a square or a rectangle table where you have like the opposite sides, you can actually have a round table where everybody is sitting and there are no sides. That actually helps. And it's actually proven that psychologically people tend to think if you're sitting on the other side of the table, there is a high chance that the person will take you as an opponent. But if it's a round table, it's more like you're sitting side by side and this direct opposition sort of a feeling doesn't grow in. One specific technique is to, arrange the seating so that all parties are sitting together facing a flip chart or blackboard where the problem is presented. That makes it clear that at all times the participants are facing the problem together instead of it being them against us or however. Distinguish between interests and positions. The classic story to illustrate is the orange story that I said. They have a different version as well. When preparing for a negotiation or after it has begun, don't just ask, what do you want? Okay, so it is also important to ask, why do you want it? And it is equally important to understand the emotions behind it. Negotiators who arrive with a complete package can create real problems. Modifications to their ideas might be taken personally. So if you are coming here to negotiate, like if you are the client who is basically negotiating, you can't have like a very fixed structure of this is exactly how I'm going to negotiate. You have to like sort of build it up on the way. Okay, you have to be flexible with it. Consider your BATNA and VATNA. If you do not reach an agreement with other, does not really make things worse for you. When you're selling an antique Rolls Royce and have received an offer of $43 to $50, you know that another potential buyer who has to do to get you interested. Of course, the first offerer may plan to use the car for a chauffeuring wedding parties, while a second offerer collects and restores antique cars and preserves their windows. So basically having a better understanding of BATNA and VATNA is very important. Okay. Silence is golden. This is what I was saying. Listening and being silent is, if you are silent doesn't mean you don't know it. If you're silent doesn't mean you don't understand it. If you're silent doesn't mean you don't have anything to say. It just means you're a bigger and a better person and you are actually listening and you're trying to learn, which is precisely why we have 2 ears and 1 mouth, okay? Because we should speak less and listen more. So silence is golden. This is true for 2 reasons, although I'm the only one speaking a lot. If one party is highly opinionated or emotional, if their approach is threatening or extremely demanding, keeping quiet after they finished speaking can be quite unsettling to them, okay? It's like jujitsu. You allow them to be tripped up by their own forcefulness. Most people are troubled by silence in the midst of heated discussion. Sometimes silence is viewed as disapproval, but since no specific disapproval have been voiced, it cannot be treated as an attack. It has happened on many occasions. When met with silence, people have modified their previous statements to make them more palatable. Yes, this is true. For example, if there's A versus B and A says to B that, oh my God, you're such an idiot. You are so dumb. You don't know how to drive or ride a cycle. You're in the middle of the road. You hit that. You don't have eyes. I don't know, you should go and see an eye doctor, blah, 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 blah. And A is constantly ranting and B is just sitting there silently. And after A has finished all this, B is just still sitting silently and not saying anything. After a few seconds, I think A will start feeling a bit odd and A might say that, what is wrong with you? Why are you not saying anything? You know, okay, I understand. Maybe I spoke a bit too much. So silence is a very, very powerful weapon. So if somebody is like constantly blabbering and, blaming and doing all these things, if you are just standing there silently, I think it really sort of pulls the plugs. Silence is an important element of the crucial tool called active listening. As I mentioned, active listening has some very interesting consequences. The listener may actually be able to get a clearer picture of the other party's ideas. And when the listener's response shows just how good a job he or she has done listening, it can shock the other party. The party could come saying that, good grief, they actually paid attention to me. So, when you actually listen to the other parties and you remember certain small things and you refer them later on, the other party actually starts believing and trusting you and say that, okay, maybe there is scope for settlement. So silence is very, very important again. Pursue fairness. You should be fair, and you should, how do I say, you should not be there to use the other party. You should not be there just for the sake of it, or, you should be taking this seriously and in pure fairness. If all the participants view the process as fair, they are most likely to take it seriously and buy into its result. Moreover, the focus on fairness can have an important impact on the substantive result. If the parties to a negotiation can agree on standards against which elements of the agreement can be measured, it can give each a face-saving reason for agreeing. Referral to the base rate of the other major lending institutions, an industry remark of marketability, or other common measures can validate the agreement parties reach. To be considered successful, an agreement must be durable. Parties who walk away from the table grumbling may regret their commitment and only honor it grudgingly. So if they end up looking for excuses to get out from or under an unwanted result, the gains achieved by the other side may prove to be short-sighted or short-term indeed. Only one person can get angry at a time. It is very important to understand this. If everybody in the room gets angry, it's going to be a terrible situation. So this is yet another means to help individuals keep cool head and pay attention. If it's not your turn to be angry or not to speak, please prohibit yourself from doing so. Do not sort of interfere and put yourself between. For example, if your party A and party B is blaming you, sitting there getting angry and blaming you, and you hear a couple of things which is not true according to you. So just stay calm, listen to whatever they are saying, and then wait for your turn to speak, okay? Do not start getting angry there and interfere in A's comment, in B's comment or whatever. Okay, that's not going to lead anywhere fruitful. Well, that's all I have for process of mediation today. So in general, I wish we could have it more physically. I know it's a lot of information to take, but I can tell you something, that if this process is actually taken into account, and if you actually follow the ground rules and try and bring it into practice, this is going to be much, much better, and it's going to make the entire scenario much better. We have so many conflicts and disputes. Apart from the ones which are pending in the court, there are thousands and probably lakhs of those who do not come to the court because they are afraid that it's going to take long hours and they have to visit so many times, and then there's a harassment of the lawyers and everything. So this is actually going to be a very fruitful and a much more civic and honorable way to resolve the disputes that come at our hand. Okay, so this is the process. I have 2 more topics for today, and I'm going to, do we need to take a break? I know I've been talking a lot. If you want to raise any point, if you want to ask something, please go ahead and ask me. Okay. Either I was too good or it's just too much of information in the morning. Okay. I know it's very difficult to keep listening to just one person talking at the same tone for so long. If it's okay with everyone, and if it's okay, sir, we could probably take a break of 5 minutes or 10 minutes, and then we can all jump in.
Yeah, I think people might also want a tea break, Ms. Goswami.
Right, sir.
Yes, sir.
Always good to have a break for tea.
Maybe, sir.
10 minutes?
Yes, sir, I think that's good. It's 11 here in India. I think it's going to be 11:30 in Bangladesh, probably. So we can catch up at 11:40.
Now 11:27, Madam Priyanka.
Okay, sir.
Your time up to 12 first session, and thereafter second session 2:30.
Second session is 2:30. Okay, sir. So I actually have two practical exercises for everyone. One of those is about opening. Okay, so what I will do is, do we want to take a break, everyone? Otherwise, I could talk about the steps and I can give that exercise and we can close the session and then we can take the rest in the second half of the day. If that sounds good.
Lordship, any suggestion?
Just to give Priyanka a little bit of time to breathe, let me give one problem for all the participants. Problem that I have thought about. So is that okay with everyone if I give you a problem?
You understand, Priyanka?
Yes?
Yes, sir. Please, sir. I think you should.
Yeah.
Okay. The problem is like this. Let's say party A agrees to buy a property, house and land from party B for a price of taka 30 lakhs. And at the time of the agreement, party A pays 23 lakhs. So 7 lakhs remains to be paid within 1 year. And then they will execute the deed. But then party B doesn't get the money within the 1 year. The remaining 7 lakhs within the 1 year. But then party A says, I will pay you the rest of the money if you register in the name of, let's say, a C. Now B becomes a bit suspicious and finds out that in fact, what A has done, he has made an agreement with C to sell the property for 40 lakhs. So B then says, nothing doing, I'm not going to sell to you. You have breached the contract, I will not sell. So A then approaches a common friend, let's say D. And D says to B, it has been now 4 years. You have not received the remainder of the money. So you claim rent for all those 4 years. You're entitled to get the rent. And the rent for the 4 years will be 10 lakhs. And that would, if you think about it, that 10 lakhs and 30 lakhs makes to 40 lakhs. And that's what A had agreed with C. So there lies the problem. What is the solution? First of all, I want to know from all of you, you're all judges and lawyers. So what is the solution in law, in a court of law, for litigation purposes? And then can we dispose of this matter in a different way. So everybody clear? A and B agree. A agrees to buy property of B for 30 lakhs, pays 23 lakhs, goes into possession. He is supposed to pay 7 more lakhs within 1 year, but doesn't pay. 4 years have elapsed. But then A says, register in the name of C, and I'll pay you the rest of the remaining 7 lakhs. B finds out that he has agreed with C to sell the property, A to C, for 40 lakhs. So B now says, I don't want to sell to you. They both approach a common friend, D, who says to B, get him to pay the rent for the 4 years, 10 lakhs. B obviously agrees to do that, but A doesn't. What is the solution? Litigation, mediation, arbitration? I want to know your answers. It's a very common problem. And this one, I can tell you, is a live problem. It's a real life issue.
Assalamu alaikum, sir. I'm Simon Al Islam. Sir, I am Simon. Sir, I am Simon Al Islam, an assistant judge from Shirazganj. Sir, I have a question there. Sir, is there any contract for sale or so-called bainanama under Section 54A of the Transfer Property Act 1882?
Yes, yes. At the time of the first agreement, there is a bainanama.
Then I think there is a bit of contract here.
Bainanama. You want dates? Make up a date. Any date. I mean, dates are not relevant. The timing is relevant. Yes, 1 year within which to pay the remaining balance, and 4 years the money has not been paid. These are relevant, but the precise dates are not relevant. Yes, there was a written agreement at the time, but not registered.
Okay, sir. So I think in mediation, it is possible.
No, I don't want to answer now. I just wanted to give Priyanka a break. I think she has had her 5 minutes break, so she can continue, and I will take your answer either later today or tomorrow.
Thank you so much, sir. That is actually very interesting, and I have something very similar that we dealt with about 2 months back. Thank you so much, sir. Okay, so since I took my breather, so I'll step into what are the steps of mediation, and after we do that, I have an exercise for all of you to get into opening statement. I think it is a very important part and sort of the most important step for doing mediation. Okay, so after we complete the presentation and the steps of mediation, I request all of you to, since all of you won't be able to present your opening statement here, I would request all of you to write down an opening statement. Okay, when we take a break, just write it down. I don't think it should take more than 15 to maybe half an hour at max. You can write it down, and after that, when we resume our session after lunch, we can all sit and discuss a couple of opening statements, and we can also mark ourselves and see how well we are doing in that. Okay, so it would be a good exercise. Let me share my screen before that. Is my screen visible? Stages of mediation.
Yes.
Okay, thank you so much. Okay, now we have talked about the process of mediation at length. Now just let us get into what are the steps of mediation. This is a bit more into the intricacies, or how would I say, the format of what a mediation is. It's more rule-like rather than vague in the past presentation. So now when we talk about the stages of mediation, this is something which we do. So we have a pre-mediation or the preliminary conference. As I said, in a couple of countries, in developed countries, you have pre-mediation counseling where the mediator sits with the parties. A couple of private mediation centers in India are doing that. I myself try to practice that with my clients, whoever comes my way. And we do a pre-mediation counseling, sitting with each participant and client and trying and understanding their perspective and explaining to them what they should be doing in mediation and what they should be expecting in mediation. Okay, because it is important to understand the expectation and to set the right expectations from the client. Because if a client enters a mediation expecting that, you know, the mediator is going to take care and is going to give them justice, that's not what is happening in mediation. So it's very clear to make them understand that what they can expect out of this. So you have an opening, then you have the party statements. So opening statement is basically it. Opening statement is given by the mediator. Then you have the opening statement of the parties, or the party statements, however you want to say that. Then you have the reflection and summary agenda setting, which is basically in your joint session. You have exploration of issues, and then you have your private session or caucus. Then you have another joint session in which you basically negotiate and try and resolve and come up with you know, interesting ideas and creative solutions. You can again have a private session, or however you want. There is no restriction on how many private sessions you can have or when you can have a private session. But generally, private session is after a joint session. So that's the practice. You shouldn't enter a mediation and get directly into private session, because it's not going to help the help set the course of the settlement. And then you have the agreement and closure, and then you have the enforcement of the agreement. Okay. Now, if I have to say in the most simple terms, there are 6 stages to mediation. Number 1 is welcome. Number 2 is the opening statement and the statement of the parties. Number 3 is the joint session, where all the parties with the mediation, with the mediator sits and discusses through. Then you have the private session of the caucus, where the party with the mediator sits and discusses through. Then you have the closing statement, which if they have already settled, they come up with the final statement saying, okay, I am okay with this, and this is what I have settled to, and this is going to be my closing statement. Closing statement is sometimes they happen, sometimes they don't happen. It's just a part of the joint session itself. But it is important to say that, okay, I have agreed to this. And then you have the settlement agreement. Now, welcome. Welcome is very, very, very important. Most of the times when we talk about the stages or the steps of mediation, we forget welcome, and that is where we go wrong. Welcome is the very preliminary or the first impression that you make on as a mediator on the mediating clients or on the lawyers. So this is where the mediator sort of introduces himself or herself, talks about the specialization. It is very basic. So for example, I have a mediation room in which I am sitting as a mediator, and somebody is walking in the door. So party A, let's say I have a dispute between party A and B today, and party A walks in first. So I stand up and I shake hands with party A, and party A sits down. And then after like a couple of seconds, party B comes in, and I stand up and I hug party B instead of shaking hands. Now, immediately my gesture in welcoming party B was more close to what I did with party A. Now, party A might start thinking that, oh my God, the mediator is more close or closer to party B. Now, this is something I don't want to do, okay? As a mediator, you have to be very, very vigilant of your body language, what you're doing, what is your gesture, when you are smiling, when you are not. It has to be all very, very controlled, and everything has to have a good meaning, okay? Now, the ideal way that I would do is once they come in, I would request them, I would stand up and shake hands with both the parties, because shaking hands is the easiest way. If I have somebody who is old and not very modern. If I would say somebody from the village, I generally say a namaste to them. This is how we do it in India. We greet them with a namaste. And if I'm doing namaste to one person, I generally do namaste to everybody there. I don't shake hands with a few and do the other thing with the others. That doesn't work like that for me. And then I request them to sit on the chairs that I have assigned to them. And how I assign is I already write down their names in a small piece of paper, which is sitting, so that I don't have to guide them where to sit. Okay. And if I am sitting, let's say, I generally try, and because I don't have a mediation room of myself, I generally rent places to conduct mediation. I generally try to take places with a round table. And when we are sitting them, so the mediator is in the middle, and I make the clients sit closest to me. And if they have their lawyers accompanying, then they sit further out in the circle. Okay. They don't sit there. So the closest to me are the two clients. Okay. And the two clients are sat in such a way that they can talk to each other and they can talk to me. Okay. Then I greet them, good morning, good afternoon, good evening, whatever the time is. According to that, I offer them tea or coffee to make them comfortable, however they like it. And I also ask them what they want me to call them. And I think it is very important. You shouldn't presume on your own what the party wants you to call them. So if, for example, it's part A and B, so I ask them, so are you comfortable with me calling you Mr. A, or should I just call you A? So he can tell me that, no, you can just call me A. And I ask, okay, so should I, to the party B, are you comfortable with me calling you Mrs. B, or should I just call you B? And she says, no, I am comfortable with Mrs. B. I said, okay, great. That is what we will call. You can call me, say, my name is Priyanka. You can call me Priyanka, or you can call me the mediator, whichever is comfortable for both of you. So this is how I set the tone, and this is how I start with my welcome. I don't talk about mediation as such, but I sort of, give them an idea, and I build a trust. Okay, I talk a bit about myself. I say that, okay, I have been practicing this many years. I graduated this with my specialization in this. I'm also attached with academics, blah, blah, blah. I'm not talking too much about myself because I have to introduce myself in the opening statement as well, but I still talk a bit to, sort of give them a sense of comfort and trust. Okay. So another thing that we need to set during this time is basically that, you set the time, it should actually be done prior. You should already get in touch with the clients beforehand, because I have had this terrible experience where we were almost at the end of an agreement, settling down with an agreement. And one of the parties came up and said, I just have 30 more minutes. Okay, because after that I have a meeting and I have to leave. And I was really stumped with it. I was like, okay, we are just about to settle. And the moment you put, timelines like that, the other party gets very startled and they don't want to settle immediately because they think it's something that they have to do it in rush. So you should be very clear. You can tell them that, okay, we are starting a mediation, and I hope that both of you have kept the entire day free, or if you have another prior appointment, please let us know beforehand that till what time will you be available. So you do all these sort of things. Okay. If there are any other scheduling issues, for example, you can also discuss about, let's say, if it gets settled today, well and good. If it doesn't, when can we do it later on, and all of that. So it's a general chit chat, but as a mediator, you have to be very, proper with yourself. And you have to greet the parties properly. If you want to offer them something, you do that then, and you have to make sure that they trust you. Okay, that is very important. Now, what are the objectives of this welcome? Is to establish neutrality, create an awareness and understanding of the process, develop rapport with the parties, gain confidence and trust of the parties, establish an environment that is conducive to constructive negotiations, motivate the parties for an amicable settlement of the dispute, and establish control over the process. This is important. Parties decide what they settle, but mediator takes charge of what is happening in the process. So as a mediator, you have to sometimes exert yourself. So you can say things like only one person speaks at a time, mobile phones are not allowed. These are things that you can say in your welcome as well as in your opening statement as well. It is comfortable. It is good to do that in both the spaces so that people really know that you are serious about it. And if you say that no mobile phones and somebody's still having a mobile phone, you can actually, like sort of see, you are not a court, you can't like sue them or something like that, but you can always tell them very rigidly that I'm sorry if this is how it is going to happen, I'm not going to take this ahead, you can please leave the device outside the room, or you can very sternly tell them or redirect them again. So you have to establish control over the process and tell them that you are the one in charge in this room. That's very important. Now, opening statement, it is the most important part, and it sets the tone for mediation. It lays down the ground rules, and it tells the parties what they want, their story, their need that needs to be done. So this is very important, and please take in mind, if you want to note down, you should, I think, because opening statement is something which is which comes with a lot of pressure, and it's very tricky to actually have a perfect opening statement. Everybody has their own perfect version of it, but yes. And I remember when I started mediation and I started observing mediation initially, I used to like request the parties and the mediator if I could record their opening statements. And I had one opening statement I remember which was brilliant, and one I remember explicitly. Unfortunately, as human beings, we only remember the bad or wrong things. But I remember this one, it was terrible. Okay, that was like the worst opening statement. That person just went by saying, hi, good morning, this is ABC and I'm going to be your mediator today. This is where we will conduct our mediation. Mediation is a process where a neutral third party helps the parties at dispute to resolve the issue. You are going to be in charge and I'm not going to decide, so let's start. That was like the worst I have ever had. You cannot do something like that. Okay, it's terrible. So what is it that you should be talking in an opening statement? You should talk about the concept and the process of mediation. And by concept and process, do not read out definitions. It doesn't help. Okay, this is not a classroom. People are there with real issues and they need to understand what is behind what they are getting into. Okay, so you have to explain the concept and process. You have to talk about the stages of mediation, that we'll have this opening statement by me, then the parties will follow with their opening statements, then we will have a joint session, then we will break into a private session. As and when we think it is important, either of your parties can request for a private session, or even I can request for a private session. And if it is accepted by all, we can take it ahead. And then we can rejoin for a joint session. And if we think we need more private sessions, we can take that ahead. And hopefully we will come down to a settlement. And once there's a settlement, we can draw a settlement agreement. And then we are good to go. Okay, so things like that. So you explain the stages of mediation. You explain the role of a mediator. You tell them what a mediator does, what you're going to do in that room, what are going to be your characters, and what is the role of the advocates if the advocates are sitting. What is the role of the parties? What are the parties going to do in the room? What is the advantage of mediation? And what are the ground rules? Ground rules basically mean whatever rules you have, like no mobile phones or no calling in and out, no leaving the mediation just because you have another meeting, no smoking in the mediation room in the middle of nowhere. Okay, so these could be your ground rules. Okay, and all of this, along with introducing a bit about yourself, has to be within 8 to 10 minutes maximum. The ideal is 6 to 7 minutes, but I know in practice it is very difficult to fit everything in 6 to 7 minutes. 8 to 10 is the maximum, because if you keep speaking more than that, none of the parties are going to listen to you. Okay, so it's not going to help the cause. So the perfection is between 8 to 10 minutes. Now, when you talk about what is the role of a mediator, you have to highlight these aspects. It is a voluntary process. It is self-determinative. It is non-adjudicatory. It is confidential. It is good faith participation. It is time-bound. It is informal and flexible. It is direct and active participation of the parties. It is a party-centric process. The mediator is neutral and impartial, and once the settlement agreement is there, there is finality in it, and there's a possibility of settling related disputes. And what is the need and importance of separate sessions? What is the importance of private sessions? And adequate opportunity. Now, when you talk about all these, a couple of things which are the most important that I think you cannot miss is confidentiality. You have to talk about confidentiality in joint sessions and in private sessions. So what happens in private sessions, if you want the mediator to go and talk to the other party, you have to tell the mediator that, okay, this is something which you can go and talk to the other party in joint session on my behalf or in the private session with the other party. Okay, so you have to explain confidentiality really, really well. Okay, and you have to talk about how the mediator is neutral and impartial, and that the parties decide and the person has no, and you can always walk out of a mediation if you are not comfortable or if you think that it is not going your way. And you cannot, nobody can be called witness or no evidence can be taken from the particular room. But if there's a settlement agreement, it is final and it is binding, much like a court order. Okay, so these are the things which you cannot miss while highlighting. Now, the mediator can generally explain these particular ground rules. I think it's good to have all of these. It's generally like only one person speaks at a time. This is very interesting concept that a couple of countries use. It's actually an old African tradition called the speaking stick. And the story is that in villages, in that particular village in Africa, I'm not exactly sure of the name of the place. I used to remember, I don't remember it anymore. So they have this one stick which is like this. Okay, it's like this, like a swan, like a face of swan. It's a stick like that, and it's called the talking stick. So when they used to have their village discussions, like a panchayat, if I have to say, so they used to have this one stick, and whoever held the stick would be the only one speaking. Now, what that ensured was nobody would speak in between, because if you're not holding a talking stick, you cannot speak. A couple of mediation centers in Canada and in Australia had started using that as a tool. I'm not sure how well it went ahead, but I think it's a very interesting idea. So they use that stick or a stone, which is called the talking stick or talking stone. Only when you have that stick or stone with you can you talk, otherwise you cannot talk. So this actually, sort of binds the idea that you cannot interfere in somebody else's speaking. So these are a couple of ground rules you need to use. Like, you should only talk when it is your turn. You cannot abuse or insult. You cannot physically assault anybody in the room. You cannot use mobile phones. You cannot chew a gum while speaking or start smoking up in the room or something like that. So these are a couple of ground rules. Ordinarily, the parties may address only the mediator while one person is speaking, others may reframe. Language may be very polite and respectful. Mutual respect and respect for the process may be maintained. Mobile phones may be switched off. These are a couple of general rules. Now, after the opening statement of the mediator and after the opening statements of the parties, you have the first joint session. Now, what happens in the joint session? The mediator basically invites the parties to narrate their case. So you basically have the parties' statement or the parties' opening statement, where they explain what happened to them, and they tell them what is it that they feel and what is their pain and what is it that they want out of this process. Okay. So if you can say the plaintiff or petitioner should be permitted to explain or state his or her case or claim. The counsel should thereafter present the case. So what happens is, if there are lawyers in the room, so first the mediator speaks, then say party A speaks, then party A's lawyer speaks, then party B speaks, then party B's lawyer speak. Now, how do you decide who is party A and party B? The ideal way to do it is right at the beginning you ask, so which one of you parties would be comfortable in starting? As I mentioned already, let's say one side is the ladies. A lot of times I have seen this and I don't think that's fair. Mediator ends up saying, okay, let's go ladies first. Why don't we start with B? Don't do that. Okay, just don't do that. It just shows that you are somewhere partial. Your gentlemanliness is not something that needs to be shown here. Okay. Just ask them who wants to go first and who is more comfortable, and whoever does, the party goes, then the lawyer, then the other party goes, then their lawyer. Okay, so the mediator should encourage and promote communication and effectively manage interruptions and outbursts by parties. You cannot let another person speak in between. This is something that you clearly manage and monitor. The mediator may ask questions. The mediator can rephrase, reframe, as I said, try and push the parties from position to issues. So all of this is done here in the joint session. Okay, it's a very tricky place, and the mediator can keep asking questions. Why do you feel this way? Why do you think? How do you think this is going to be about? Or something. You ask whatever valid questions you think fits the scenario. The mediator would then summarize the facts as understood by him to each of the parties to demonstrate that the mediator has understood and is listening. So once the parties have completed, it is a good practice for the mediator to summarize whatever the parties said and, sort of rephrase or reframe them in your words and say it back, saying that, please tell me if I understood it well. Doing that, it sort of helps. Okay, so if A said, B crashed my car. So I said, okay, so you are upset that your car was damaged. Am I right in saying this? So you will say yes. Now, immediately the focus shifts from B damaged the car to A's car is damaged and A is hurt. Okay, so this is what it basically does. So the mediator has to summarize and present it again. And in this process, you reframe and rephrase things again. The mediator shall identify the areas of agreement and disagreement between parties. And as I discussed earlier, you can have like an issue list that you make while doing these joint sessions. So you have like issue 1, then issue 2, issue 3, issue 4, and then you decide on which issue you want to go first with. So if you decide, then you can number them accordingly and things like that. You can always do that. If you're writing it in a whiteboard or in a white paper or wherever, you can always, and you should always destroy it once the mediation is completely done. It doesn't mean that, you had one session today and tomorrow you have another, or, you have another in the next month. You don't destroy it then. For those cases, you keep it there. But once the mediation process is done with, either it's settled or not settled, whatever the way, you finish it off. Okay. Now, what is the objective of this joint session? It's to gather information, provide, that is to provide opportunity to the parties to hear perspective. Understand is to understand perspectives. It is very, very important as a mediator to have an eagle's eye. You are flying from the top and you're trying to see what both the parties are seeing. Okay, it is very important to have a complete perspective of the situation and understand the facts and issues, understand obstacles and possibilities, and to ensure that each participant feels heard. Okay, active listening is very important. I'm sure you should have had or would be having a session on active listening and body language. Active listening is something which you have to involve if you ever think of being a mediator or even mediating, mediator, because we are all sitting judges here. So yeah, that's very important. Now, private caucus. Now, what happens in a private caucus? Now, a couple of pointers to remember while doing private caucus. When you move from joint session to a private session, what happens is you move with one of the parties. Now, this can be done when, say, for example, you're having a very smooth joint session and you think things are going in place. You don't need to pull up and say, okay, let's do a private session just for the sake of it because you have read it. There is a format of private session. No, don't do that. Okay, don't do that. That's not important. That's not needed. Only when you think that probably the discussion is going nowhere, or the temperature of the room is increasing, the things are getting heated and you need to break it off, or either of the parties request you that if it's okay, mediator, we would want to have a private session with you. In such cases, you take a private session or a private caucus or however you call it. And couple of things to remember: if you are taking a private session with party A, even if party B says I don't need one, you should have a private session.
Priyanka, now 12.
Okay, sir, I'll wrap it up in like 5 more minutes. So you sort of say that Private session, you can say that, okay, no, I should have a private session with B as well, and you try and time it. Okay, so if, for example, with A you're sitting for like 20 minutes, with B you should want to sit for 20 minutes. Okay, now if it gets over before that, that is a different thing altogether. Whatever you have a discussion with A in private caucus will not come out unless A wants it to come out. Okay, so you have to reaffirm. So the moment you get into a private session, you talk about reaffirming confidentiality first, and whatever happens here is confidential unless you want me to go out and speak about it. Okay, and what happens in private session is sometimes parties are more comfortable sharing more information, so the mediator actually gets a better idea of what is happening in there. Now, what are the objectives? Is to understand the dispute at a deeper level, provide a forum for parties to further vent their emotions, provide a forum for parties to disclose confidential information which they do not wish to share with other parties, and understand the underlying interests of the parties, help parties to realistically understand the case and shift parties to a solution finding mood, and encourage them to generate options. Now, this is basically an understanding of what is individual meeting and joint meeting. We have discussed this. Then we have the settlement agreement. If it is coming down to that, we can orally confirm, the mediator orally confirms the terms. Then you have to sort of, as a mediator, you have to judge about the practicality of the settlement agreement, and you have to get it copied, and then you have to send it to the court and get a referral from the court for passing it as an order. Okay. Now, I won't get into Vatna too much right away. What I will do instead is I have a small case for everybody to work on. What I need all of you to do is you write down your opening statement in there. It's going to take some time. If we want, maybe we could take 15 minutes in the beginning of the next session where everybody can write it down. And I have a couple of pointers to check. We will discuss a couple of opening statements. If you think your opening statement is perfect, you're more than welcome to come and speak. Even if you think it's not, please try and write down the opening statement, because I think it's very important for all of us to understand what to include. I'll send the problem in the chat. Just give me a moment. I'll just send it through the chat. Okay, so this is basically a problem statement. Find everyone. Okay. It's a very simple and a very genuine problem. We all see this. So let's say this is the problem that has come your way and you are the sitting mediator and the parties are there with you in the mediation room, and you have welcomed the parties into the room and you are now presenting your opening statement. So in those regards, just write down the opening statement because we can't discuss everyone's here at this point. We don't have time. So we'll do that and then we'll catch up on try and marking these by ourselves. Okay, does that sound good? Okay, so I think you can all copy and paste it from the chat here.
Okay, should we all go for a break now?
I think so, sir. If everybody's already taken that down, we can definitely take a break.
If they don't switch off their laptop or whatever, then it will remain in the chat box.
Yes, that's true.
So they can come back to it.
I think. Thank you, sir. I think you can take your lunch break. You have been very kind to be sitting around. Goswami sir, I think we can take a break. If everybody is keeping their laptops on, or if they have copied the chat, I think they can all get the problem. That I have.
Okay.
Yes, sir.
আমরা আবার 2:30 আবার জয়েন করব।
Yes, sir. Okay, thank you everybody for being such wonderful participants, and we'll catch up. Try to keep in mind whatever we discussed as essentials for opening statement. We will try and give marks on the basis of how well you draft your opening statement. So that's that, and I'll see all of you again at 2:30 p.m. Dhaka time. Thank you so much. Have a good day.
আমরা আবার 2:30 জয়েন করব।
Good.
Yes, Ashadi, we may join at 2:30 p.m. in Bangladesh time.
2:30
Yes.
Bangladesh time. That will be 2 o'clock India
2
time.
o'clock India time. Yes, 2 o'clock
Yeah.
India time. Yes.
Yeah.
Sure. Thank you.